It's a beautiful day, but you can start feeling that fall is right around the corner as the cool temperatures start coming in earlier in the morning and later on in the afternoon. Hi, I'm Darren Findling from the Probate Pro, and as we approach the beginning of the school year, we get calls from individuals who are preparing to go away to college, and they ask if it's appropriate to have powers of attorney or other planning documents in place so that in the event that their now 18-year-old is, God forbid, involved in an injury or a health issue, that somebody has the authority to make a decision. This type of document, often referred to as a patient advocate designation or living will, is a common document that older people or people who have gone much further on and have established some wealth use within the collective documents for an estate plan. But there's great value in the creation of these documents for somebody as young as an 18-year-old or somebody leaving home for the first time because of various laws, including HIPAA, which is the federal protection of your medical rights. And within these patient advocate designations, you can designate lots of things and give authority for a third party to act in the event that that now 18-year-old is unable to do so. Without the document, it would be a requirement to gain authority over that individual if they were unable to communicate their wishes, and you may have to go to court to establish a guardianship. So a really effective estate planning document is this thing called a patient advocate designation or living will. Now, Michigan, through the Michigan Department of Health and Human Services, actually has a pre-created form that you can simply download off the internet, and you can go to our website. We're happy to give that to you for free. And that form is created such that you fill in a variety of blanks. It allows you to designate a third party to serve in the role of the patient advocate, meaning the person you're designating to make the decisions when you're unable to do so because of health situations or you're unable to communicate your wishes. As well as it allows you to identify certain things that you'd like specifically done for yourself. So for example, if you're one that wants, in an end-of-life decision, wants no medical intervention at all, you can designate that. And on the other hand, if you want full medical intervention, you could also designate, or anything in between there. So you've got great flexibility in both the designation of who you want to serve as well as how you want to be treated. Now, this statutory form can be a little concerning to lawyers like myself, and here's why. The signing requirements and witnessing that go into a patient advocate designation, this pre-approved form, are more stringent than the signing requirements that are used within the creation of a will or an estate plan. So the witnesses, for example, must be disinterested parties. They can't be medical or family. So often people find the closest people to them and they witness the patient advocate designation, which could render that document void or voidable because the document was not signed appropriately. So it's critical that when you create a document like this, that you don't just do it and then not follow all the other requirements. And that's why we always recommend that you use a lawyer to create a patient advocate designation as well as any other estate planning document, because failure to execute that document could render it voidable in the time that it's most critical that that document be effective. Now, we all remember the news stories of some people that have been in court battles over these types of designations about end-of-life decisions. And those are really anomalies. They don't happen often, and they usually happen when there's a tug-of-war between different family factions, and then all of a sudden the hospital system is caught in the middle of it. But the beauty of these documents is that the document in writing identifies your preferences, rather than just simply leaving it to a judge to interpret what you may have wanted in the event of these end-of-life decisions or decisions upon which you're unable to make decisions during a very short period of time, a health outbreak that may come upon you. So these patient advocate designations are really valuable documents. We encourage everyone to do it, from the time you're ready to leave that house, all the way through the last time that you could affect one of these documents when you're a senior. So a really, really good estate planning document. I strongly encourage those who are ready to leave to college or going into their second, third, or fourth year of college to create your first estate plan. This is really the beginnings of estate planning that will occur throughout your life through a patient advocate designation, living will. If you've got questions about this process or the document or want a free sample of one, give us a call. We're happy to help in any way. You can reach us by visiting our website at theprobatepro.com or call us at 877-YOUR-FIRM. That's 877-YOUR-FIRM.